before it has come to my attention that if we read through the public comment section by Mr. Melton, there was an issue where concerns about the handling of complaints against developer Donald Trump and Mayor Jimenez, but there was also mention as to Mr. Rousseau, Ed Rousseau. So the only amendment that I would seek, which I believe is appropriate, is that Mr. Melton also referred to Mr. Rousseau in his comments. So I would just move that we add that name to the paragraph on public comments. Does anyone else have that recollection, or was it just me?
I have no independent recollection of the people who were named during that discussion. So I would move to amend based on your recollection.
So all we're changing is after Donald Trump, we would add the name Ed Rousseau. There was a complaint filed against Mr. Rousseau. It was the issue, my recollection is that it was brought up. And again, it doesn't, I don't think, change in substance of the area, but I think...
And if you indicated it was brought up by Mr. Melton, he's sitting here, why don't you just confirm with him that he did it?
Mr. Melton, why don't you come up and confirm if I have accurately characterized your comments.
For the record, Dusty Melton, 3430 Poinciana Avenue in the city of Miami. Yes, my oral and my written presentation last month addressed in some significant form the complaint that was filed against Mr. Rousseau.
Thank you.
Thank you, sir. So with that, we will proceed. We have an agreement, I think. All in favor of this amendment?
Okay, so the judge moved to amend. Is there a second?
Is there a second?
Second.
All in favor?
Aye.
Any opposed? Hearing none, the amendment passes. Any other comments regarding the minutes from the meeting of July 8, 2015? Hearing none, do I have a motion to approve?
So moved.
Second.
All in favor?
Aye.
Any opposed? Hearing none, the minutes are approved. The second item on our agenda this morning is the public comments. Speakers are limited to 3 minutes. We welcome anyone in the public who wishes to come up at this time and make any public comments to do so. Good morning.
Al Crespo, 689 Northeast 92nd Street. For the record, may it show that the judge has left the chambers. Therefore, this meeting does not have a quorum. So that's number one. Number two, the minutes of this meeting indicate that the, that the judge walked out. Commissioner Suarez recused himself from the vote. I believe Florida law requires that anyone who recuses himself from a vote has to file a document within 15 days establishing why they recuse themselves for a vote. I am asking, therefore, for a copy of that document. That's a public record request to all of you. Secondly, in relationship to the item that's coming up before you today, Crespo versus Rousseau, it is my recollection that Commissioner Nareen, is the person who made the motion to postpone this item, and that she indicated that she was concerned and wanted to raise some questions and investigate this. I know that she is not present. I would ask that this item therefore be postponed until she appears, because she's the one that made the motion. She raised the concerns. It's only fair and that she be allowed to provide some discussion or insight into why she made the motion that she did. But specifically, the judge has left the room. He did not recuse himself. That's illegal, right? And he filed a notice 15 days after the fact for the last meeting. I want a copy of it.
Thank you, sir. Any other public comments at this time?
Yes, that's true.
Hearing none. Ms. Crespo,
Yes.
please. Hearing none. Judge. Okay. The next item on our agenda will be Roman numeral number 3, section 8, Ms. Diaz-Greco.
Good morning, Commissioners. It's been a really busy month with public housing. With respect to Section 8 request, there was a new third-party administrator that was hired by Housing, and we've seen some delays in the compliance process. We're noticing now that we're starting to receive these requests of opinion as they're required by the code. Probably it was a training issue. With respect to Section 8 requests, these are very important because they're an example of the code's limitation on county employees contracting with the county. And the limitations set forth in subsection C of the code are that an employee may contract with the county, but they may not contract with any department that oversees the particular contract that they are seeking. This is an example of that. In this case, the following county employees are landlords, and they are seeking to contract with the housing department under the federally funded Section 8 program that subsidizes landlords who rent to low-income tenants. Part of our review, and we do quite a bit of review in this case, is to verify that neither that employee nor their immediate family member is involved in this case, the Section 8 program, in administering it, overseeing, issuing the vouchers, etc. When we make a recommendation for approval is because there has been verification that this employee works in a separate department and neither they nor an immediate family member is responsible for overseeing this program. In this particular case, we have 2 county employees that have requested to become Section 8 landlords under this program, and we are recommending approval given that neither they nor their immediate family members work at public housing nor oversee, administer, etc. We've made lots of amendments to these opinions, including the fact that this is for the entire period of time that they are contracting with the county. There have been some interesting situations where employees first became Section 8 landlords and then ended up working in the Section 8 department. And clearly that became a conflict at that point. So we have made it very clear in the amended opinion letters that are sent that at no time that they are serving as a Section 8 landlord or contracting as a Section 8 landlord can they work in that department. So that's a little bit of an update on Section 8. Always lots of interesting issues going on with respect to contracting with the county.
Thank you. We'll move on to section 4, which is our summary of inquiries.
Yes, and if I may, I just wanted to highlight a couple of these. I wanted to highlight 15-120. This is under 2-11.1 subsection Q, so the so-called 2-year rule, and this is something that we deal with very regularly. Q prohibits former county or municipal employees, governmental employees in fact, from lobbying their own governmental entity for 2 years after they terminate their governmental employment. So in other words, if you are a City of Miami employee and you retire for 2 years subsequent to your retirement, you cannot lobby the City of Miami Beach on any issue. In the same way, if you are a county employee and you separate from the county for 2 years after your separation, you may not lobby the county. In this particular case, it's very interesting because this falls within an exception. In this case, there was an employee that was still within the 2-year period and was seeking to lobby on behalf of a neighborhood association on an unpaid volunteer basis. In this case, because that particular activity is exempt from the lobbying requirements under subsection S, the employee was permitted to lobby even though they are still within that 2-year period. Because again, that particular activity is an exemption under the lobbying ordinance.
So are you saying lobbying for, as an unpaid representative of a homeowners association?
That is a
Is it exempt?
specific exemption under the code.
Okay.
As long as it's unpaid, it cannot, you have to be doing it on a volunteer basis. So that falls within certain exemptions that there are in the lobbying ordinance, Judge.
Okay.
So I think that was an interesting, the code is ever interesting, is it not? I also wanted to highlight Sec 15-127. We have been in this whole financial disclosure cycle with most of the financial disclosures being due by July 1st. So we're still dealing with some of these issues. In this particular case, the question arose whether an elected official was required to file an outside employment statement. And the answer to that is no, because specifically under subsection K, this requirement to file financial disclosure for outside employment applies only to departmental personnel and to county employees. It does not apply to elected officials. That is not in the ordinance, in the group of people that have to file this particular document. And the last one that I wanted to highlight is 15-133. It is an interesting situation with respect to the lobbying under the county code and lobbying under the City of Miami code. And as the commissioners know, we also have the jurisdiction to interpret the ethics code of the different municipalities. Under the county code, if a person is appearing in front of a quasi-judicial in a quasi-judicial proceeding where no ex parte communications are permitted and it's a public hearing, that person is exempted from registering as a lobbyist. However, the City of Miami sets a stricter standard. It does not have that exemption. So in this particular case, under the City of Miami's ethics code, the architect did have to register as a lobbyist, even if it was appearing before a board that was sitting in its quasi-judicial function. So interesting, these variations that we have sometimes with our code and with the municipal codes.
Very well.
But is
Thank
he
you.
really lobbying? I mean, if I'm reading your description correctly, he was asked to appear by the board to give them information on something that they were working on, and that makes him a lobbyist?
That's the way that the Miami code is written. Under our code, if you're appearing when you are sitting in a quasi-judicial function, the person would not be required to register as a lobbyist. The City of Miami does not have that exemption. What the exemption they do have says that, however, if they are simply appearing because the commission has asked them to appear to answer questions, then under that situation, they don't have to register as lobbyists.
Well, it says his sole purpose for appearance was to provide factual information requested by the board members. So I guess what I'm confused with is who was requesting the factual information, if he was being asked to provide factual information because of a presentation made by somebody else other than the board?
So I believe the way that the question came to us is that they had to register if they were in front as a lobbyist, if they were appearing in front of a quasi-judicial board. And so our answer is that under the City of Miami's ordinance, you do, unless the reason why you have been called to that quasi-judicial board is to answer specific questions, that they have called you for the purpose of answering specific questions.
I understand that. The problem that I'm having is if a group made a presentation to the board and the board asked questions, which then required the group to bring this person back, then I would understand why he would have to register as a lobbyist under the city code the way that you're explaining it
Right.
to.
That's correct.
Is that what happened here?
No, apparently what happened here is that he was simply appearing in front of the quasi-judicial board, and we just advised him that he did have to register as a lobbyist unless, and we were not given those facts, unless he was appearing specifically because the board had asked that person to appear.
That's the part that's missing, and that's the part.
And perhaps we can clarify this description, Judge. Thank you for that
I
clarification.
wouldn't want anybody else to read this
Absolutely.
and think under other factual scenarios, they didn't have to register.
Agreed, and we will make a change to the summary to make it clear, Judge. Thank you.
Very well. The next item we have is a summary of public housing and community development housing assistance inquiries.
Yes, very quickly, the difference between these and Section 8 is that these are employees that fit the low-income standards for public housing assistance. And so they come under a specific exemption in the code under C55, which basically says that a county employee that is otherwise eligible to receive income assistance or housing assistance, as long as they meet the guidelines, is allowed to do that as long as, again, they are not responsible for administering this program. Again, we go through quite an extensive review process to verify that each one of these employees does not work for the housing department and they do not administer the particular aid that they are seeking, and neither, do their immediate family members. So these employees that are listed here, we conducted this review, and given that neither they nor their immediate family members work for public housing, nor do they administer these programs, we recommend approval.
Do we have a motion?
And we accept housing assistance programs, evaluations of the necessity or of the fact that these individuals fall within the guidelines?
That is partly what we do, and the other thing that we do, and this created this entire process, and you have raised this concern, and it's partly why we made these forms this way, Judge. There is an attestation that is included in the application for an ethics opinion, and part of that attestation is that they are attesting to the fact that the information that they have provided is correct. They have to sign it, they have to date it, and then the housing department arguably also is responsible for making sure the information that they're providing is correct. And in the training, we also highlighted that these are federal programs that if you do not give correct information, it can rise depending on the severity of it. It can rise to the level of fraud and can even perhaps have some criminal prosecution consequences. So this was something that was highlighted in the training that was given to the almost 500 housing employees.
Yeah.
Yeah, we've got that question before. Do I have a motion?
Sure, move to approve.
Second.
All in favor?
Aye.
Aye. Any opposed? Hearing none, the motion passes. The next item on our agenda is our Executive Director's report.
Yes. Good morning, Commissioners. The first matter I wanted to bring up is our annual Ethical Governance Day that we have sponsored for the past three years. This will be the fourth year that we have had this program for introducing into Miami-Dade County classrooms attorneys, civic leaders, elected officials, volunteers who have agreed to take some time out of their day to address high school students in the public schools regarding civic responsibilities and civic involvement. It's been a very successful program, I would say. The schools have been very favorably receptive to it. The school board has been, and they have continued to support the program. We have selected October 22nd as this year's Ethical Governance Day. That's a date that was suggested by the schools based on the schools' schedules.
That's a Thursday.
Yes, it is. And
Opposed to Fridays.
the school board has already, at its last meeting, acted on it and approved it, and I'm asking for the Commission on Ethics to, again, to approve the resolution that will designate October 22nd as Ethical Governance Day, and hopefully we will continue to get the support we've had in the community. We've had hundreds of volunteer speakers. I know some of the commissioners have been involved in this also over the years. We look forward to it every year, and I ask the Commission to act on the resolution.
Very well. And let me just add, I've been obviously involved in it for the past few years, and the Commission on Ethics does a great job of putting it on, along with the Miami-Dade County Public Schools. And let me just continue to encourage my fellow commissioners and those of us here to be involved in it if you can, because it really is, we've received such great feedback, and you're really making an impact on educating the kids of our community, which is really the most important thing. I think one of the most important things that we can do is make the next generation focus on the issues of ethics and civics. It's just a wonderful event, and I truly get a lot out of it. I think the kids get a lot out of it, and and I've encouraged all of my colleagues to join in.
You're asking for a motion to approve that date?
Yes.
I move we approve October 22nd as the date requested by Mr. Centurion.
Second.
All in favor?
Aye.
Any opposed? Hearing none, the resolution passes. And again, let me encourage you, everybody to start signing up early.
I wanted to bring up also the open investigator position that we had open due to the retirement of former investigator Manuel Diaz. We got close to 100 applicants for that position. We have narrowed that down. We have conducted interviews. In fact, we have now made an offer to an individual, and I'm hoping that we're going to have that finalized this week. So probably by the next meeting, we should be able to introduce our new investigator to the commission. The other matter is the Public Service Honor Code, which seems to have been around for a while without yet reaching the county commission. I am here to report that after a year and a half, it is now finally, it has been presented to the county commission, and at least it will be appearing on an agenda. Now, it's been submitted, it's been referred to a committee, and we've had a number of meetings, and I think I've made the commission aware of the fact that there have been meetings with Commissioner Sosa, who's the sponsor, will be the prime sponsor of it. She has had some issues that she wanted to clarify and some suggestions that she made. We've also had sunshine meetings between Commissioner Sosa and Commissioner Levine Cava, who has an interest in it, and we've also included the Inspector General. There have been some changes which I don't think really detract from the major thrust of the proposal, but although it's not the proposal that I initially conceived of exactly, and it's not perhaps not the one I would most favor. I think it does essentially accomplish most of what the original proposal would have accomplished. I will point out the major change that's been made on the implementing order. I've included in your packet the resolution that the county commission now will have before it to act on the honor code, and the implementing order that will essentially put it into place, assuming that it is acted on favorably by the county commission. The original one that we drafted and presented had a requirement that pretty much anything that would constitute gross ethical misconduct would be required to be reported. That has been altered to require the reporting of information that may constitute a crime, which will cover most of, I think, of the issues that we anticipated would be falling under the code. However, and the original proposal kind of defined, gross ethical misconduct, which was a little confusing to some people. We do still have in here a provision under responsibilities of supervisors and ethics officers, the requirement that all employees be counseled and encouraged to report ethical violations, to report waste, fraud, or abuse, or any other type of misconduct. It doesn't fall under a mandatory requirement, it's under a suggested policy, which we will, of course, be training the county employees on. I also think it gives us an opportunity to do something we've been wanting to do for a while. There is a policy in the county for every department to have a designated ethics officer. And they have been designated, but frankly, they haven't been utilized much. And I've had the idea, and I think so has Mr. Morosky, that we need to try to encourage the county's ethics officers from every department in the county to be more engaged and involved in ethics issues. And I see this as an opportunity to use them, to supplement the training that we give to county employees, and to have them on a regular basis, be sort of liaisons between our agency and their departments. We will probably provide special training to them so that they become more knowledgeable than the average employee, and then can be used as a resource within their own departments for people who have questions, and we'll have a better idea of what they should be referred to our agency. Being the the size that we are, we cover a lot of ground, we cover thousands and thousands of employees and public officials in terms of training, but it's still important to have as much information in circulation as possible, to have as many people who are informed on these issues as possible. We see this as an opportunity now to engage in the county, people from every department to be more or less our surrogates and to work with us. So I see that as a positive thing. We have made a few other minor changes to the enforcement. We've added a protection clause for the protection of employees who might feel that they are being somehow hurt or retaliated against for complying with the honor code. This is we're breaking some new ground here with this concept, and I am excited about it. I think it's something that if it gets implemented properly, will have a real impact on county government, and I want to make sure that the commission was updated on where it is. I expect within the next couple of months that it's going to be acted on, at least by the committee and within the commission, and then we'll go to the full county board. I will certainly be there to testify on behalf and in favor of it. I've made everybody aware that this is something that the commission endorsed, and so when and if it does take place, it's something that I think we can look at as something positive that we accomplished. So I wanted to give that update.
When is it set to go before the commission?
Well, it's not yet set on the commission agenda. It's been referred to a committee. So the next SPAGO committee is what it's called. The next meeting, I think, of that meeting, which will be either in September or possibly in early October. When that meeting occurs, that's when this will be taken up. Assuming it gets a positive recommendation at that time, it will then be forwarded to the county commission at its next meeting after. So sometime this fall, we expect this to be before the county commission.
Very well. Thank you, Mr. Centurion. Our next item are the complaints in open session. The first one is the Commission on Ethics versus Carlos Hernandez. What we have on the agenda is the ratification of the letter of reprimand. And ask my fellow commissioners to please take a look at that if you haven't already. My question regarding the letters is, Mr. Maneski, and again, it's just for purposes of background. I know we sit here after a public hearing on July 8th. Do we want to go into detail as to the witnesses that testified, the individuals who didn't appear perhaps, or is that something that was...
not something that we typically do.
Okay. I wasn't sure. I know that we sent other letters of reprimand, and I just wanted to... I had that inquiry. I don't think that it's incorrect the way that it is written down, but I had that question.
I can't recall that we've ever sort of delineated what each witness's testimony was.
I have a problem with some of the language on page 5 of the letter. The statements that you write, Mayor Hernandez should be ashamed of himself. Mayor Hernandez should take these words to heart. The commission expects the mayor to take this reprimand to heart and hopefully guide him in future endeavors. I don't think those kinds of statements are professional. As far as being in a letter of reprimand, I think there's a better way to express it. I'm not sure what, but I'm uncomfortable with that language. It's something of this magnitude.
And let me just add, because I actually highlighted some of the same ones that my fellow commissioner just addressed. There was one on page 4 where you referred to, in his mind, should be an embarrassment to any public official. Again, I'm not saying whether it's true or not, but in terms of the language, I think that it could be changed. And it starts with Mayor Hernandez's convoluted explanation as to why the monthly payments he received from Mr. Flores did not constitute profit, and in his mind should be an embarrassment to any public official. Again, I think that it's a poor word choice. I think it could be worded differently. I'm very big on making sure that we say what we mean what we say, and I don't think that type of language, as well as what my fellow commission just mentioned, they should be ashamed of himself. The one where make sure that their actions, well, that's fine, but making sure that their actions are fully complied with the law, I don't have a problem with, which is the paragraph before the last one, but the one where this public letter of reprimand should be taken to heart. It should guide his future behavior, but I'm not getting out of that one.
Is that
Being,
too
being,
soft or
being,
too
I
hard?
think that we need to change the letter and change the
For
tone.
me, I think it's too childish.
Okay.
Yes. Agreed.
You know, you tell an 8-year-old you should be ashamed of yourself. I don't think you tell the mayor of the city you should be ashamed of yourself in a letter of reprimand from this commission after we conducted a 2 or 3 hour trial. I think there's a better way to tell him that his behavior was against public policy and in violation of everything that he violated.
Yeah, I echo those concerns.
I agree. Okay, we could do a redraft between now and the next meeting, and
That's what I think would be appropriate.
okay.
We all agree?
Yes.
As it stands now, I certainly would vote to approve. The next item up is Crespo versus Russo, and I do know that one of my fellow commissioners has recused himself when it comes to matters involving Mr. Crespo, which would mean that we wouldn't have quorum to address this matter, unless you think otherwise, let me know.
I don't see any way around that, so
I don't either. And so,
concur to it.
and Mr. Crespo, I know you brought up the issue yourself, I know you're present, and regarding the issue for reconsideration, I know Mr. Melton, you're here, but they involve Mr. Crespo, and we wouldn't have a quorum, and I do agree that Commissioner Mayreen, having read through the minutes, she's the one that brought up the motion. Obviously, I seconded it, and I had certain concerns. I do think it would be appropriate to table this until the next meeting.
Mr. Chairman?
Yes, sir.
The judge has to provide a reason for the recusal. He just can't recuse himself. He has to provide a reason why he recuses himself, and it has to be a legitimate reason within the statutes.
Mr. Crespo, I understand that,
Definition.
and I'm just saying that at this point, we
I'm
don't need
just-
the back and forth. You said your piece, and you said that in
I'm
the.
just pointing
in
it out
3
for the
minutes, And I
record,
know
sir.
because he's present, perhaps you're doing it again.
I'm just pointing it out for the record, you know?
Very well.
I'm gonna have a record of
I understand that,
this.
Mr. Crespo. I fully understand that. And I appreciate your comments, but it's inappropriate at this time to
just-
bring that up again. It's already been brought up, and we understand. As far as tabling it, as the chair, I'm going to make the motion that we table C-1505, the ratification of the letter, as well as there were some issues that were brought up by Mr. Melton that involved Mr. Rousseau, as we mentioned earlier, as well as Mr. Trump and the mayor of the county. So at this point, because it involves Mr. Crespo, because Commissioner Nayreen is not here, we wouldn't have a quorum. I think we need to go ahead and table all those issues regarding Mayor Jimenez, Donald Trump, and Mr. Rousseau until the next meeting in September. And I apologize for those individuals. I think council's here.
Mr. Chairman, just
Mr. Crawford.
respectfully requesting the issue regarding Mr. Russo's letter of instruction is something you would need to take action on, so you need to have a quorum here. Would you allow me to bring up under the old business category to at least address some of the comments that were made about me at the last meeting concerning the Trump complaints and the Jimenez complaints? 'Cause I really think those need to be addressed. I've seen some recent newspaper articles where Mr. Melton just continues to misrepresent facts to the press and put out there in the public things that simply are not true. And I think they need to be addressed sooner rather than later.
I can appreciate that, Mr. Borowski. However, because we don't have a quorum today, and because my fellow commissioner would recuse himself, because this involves a matter that was brought up, the complaint was brought up, I understand that you may have those concerns, and perhaps there's another forum for you to address it. I understand that this would be an appropriate forum. I don't know what other forums exist for you to respond, nor am I suggesting that you do. I'm just saying at this point, I don't feel that it's appropriate. Again, I have another fellow commissioner here, and I welcome your opinion if you have any on this issue, but it would be my opinion that we cannot bring up this issue, whether it's new business or old business at this time.
Until there's a quorum.
You can write me a letter, I'll publish it.
Or,
Until there's a quorum.
Mr. Cresswell, please.
No, I just offered, he writes me a letter, I'll publish it on my blog.
Please. Any comment as to that? Yes.
You made a motion to table the item. Has that been seconded?
Motion to table 1505.
I've made yes,
Is there a
and
second?
you're absolutely right. I motion to table 1505, which was the ratification letter, but there was also the issue, and I don't necessarily see it here, which Mr. Melton brought up. I guess it goes along with that letter, but it was more broad than that. I don't know why it's not even on, I don't see it here on the agenda, but perhaps it was to be included in that or brought up in old business. Nevertheless, I don't feel that it's appropriate, and my motion would be that we table that, and we table the issues that were brought up by Mr. Melton previously because we don't have a quorum.
Second.
All right, all in favor?
Aye.
And at this point, we will.
There's been no vote by the judge.
I'm not voting, I recuse
Well, then
myself.
you can't
So
take action at all.
essentially, by matter of
It'll be
operation,
deferred, I think, to the next
we're
meeting.
tabling it to the next meeting.
Yeah,
But I understand where you're coming from, Mr. Pressman.
Just
The
want it
reality
for the-
is you
I want
can't-
it
you
for the
can't
record.
vote. So I just want to be clear that our opinion stands that this should be tabled. And so at this point, as a matter of operation, that's what we're going to do, seeing as my fellow commissioner has recused himself from these matters. And I understand your opinion, Mr. Pressman. So with that said, we will move on to the next order of business, which is the matter of C-15-15, which is in Ray Jones versus Lewis.
Good morning, Commissioners. This matter was before you at the last meeting where you did not find probable cause to proceed with this complaint. Specifically, this complaint dealt with the production of public records, and you found that the Citizen Bill of Rights, Section 3, extended to the inspection of public records rather than their production. However, you did order a letter of instruction be issued to the respondents in this case. That would be Ms. Lewis and Mr. Carbonell. And you have before you a letter of instruction. Specifically, you requested that the letter of instruction instruct them to develop and maintain a standard operating procedure for the receipt and the processing of public records requests, to arrange for training on public records, and to provide a status report within 90 days to report on the training as well as the any procedures which have been implemented in Miami-Dade Transit with respect to public records. All that has been made part of this letter of instruction, and we are requesting that you ratify it at this time.
Mr. Chairman, it's not in this document.
I'm sorry?
There's not a copy of this
The
letter
copy
in
of the
this.
letter of instruction is not in your document.
No.
We'll make it available to you.
We'll make it available.
Yeah,
It
but
should be there. and
It should be there, sir.
So I will, if you could just wait around, I'll make sure that I
I'll
get
do
you
my
a copy.
best.
Totally. Fellow commissioners, have you had a chance to review it?
I have. And I move that we approve it.
Do I have a second?
Second.
All in favor?
Aye.
Any opposed? Hearing none, the approval of C-15-15, the letter of instruction is ratified.
Now, based on the letter of instruction, can we flag 90 days roughly from now so that we know
Mine outside while we go in
there's an
closed session.
affirmative response that's necessary within 90 days?
So we could set it,
I just want to make sure that we get compliance with the letter of instruction. No point in telling them they have to do something within 90 days and then not worrying about whether or not they do it.
yes, Commissioner, I would request that perhaps we set this matter for a status report in November.
Okay, perfect. So in the November agenda for status.
Go ahead and approve that in the minutes, please. Very well. Thank you, Mr. President. The next order of business is the in closed session, C-15-22.
Mr. Chairman, before I leave, I'd like to point out that there were no copies of letters of instructions in the minutes, and as the complaint in the case that was supposed to be discussed today, I never received a draft copy of the letter of instruction, and this is not the first time this has occurred. I've complained about this in the past. I mean, it reflects badly on the commission.
Yeah, I guess I'm gonna have to make copies. I'm,
Opposed? Hearing none, you find that C-1522 is legally insufficient. The next one is C-1521.
Then move to dismiss for the matter not being legally sufficient.
Second.
A motion and a second, all in favor?
Aye.
Any opposed? Hearing none, the motion passes. We find that C-1521 is legally insufficient. The next order of business this morning is old business. Do we have any old business other than
I
what
do.
we've addressed?
oh,
Almost
I'm
a race
sorry.
to the podium.
no, please. After you.
Good morning, Kendall Coffee, 2601 South Bay Shore, Penthouse 1 is my office. And I don't want to speak if it's out of turn or out of order. I, of course, in turn for Mr. Russo and also represent the Trump Organization. I don't want to speak about that matter. I did want to make a very brief comment about, and just general comments about allegations concerning Mr. Murowski. Because I take great exception to any suggestion that he pulls his punches with anyone. I may be the only one in this room who's actually had a trial against Mr. Murowski. It was a very tough, hard-fought case. I thought he had a tough case, a circumstantial case. But you may remember, Mr. Chairman, it went down to a 2-2 vote. And this is a very determined, aggressive advocate. He doesn't pull his punches against anybody. He lands hard punches, but he doesn't hit below the belt. I just wanted to be emphatic about that. And I can speak to the other issues whenever we reconvene in September.
Those issues are certainly not to be addressed at this time for the reasons that we've stated. We will try to hopefully have quorum and our other fellow commissioner present at the September meeting so we can address the matter that's regarding Mr. Rousseau, Mr. Trump, and Mayor Jimenez.
Thank you, Mr. Chairman.
Thank you for your time, everyone. Do I have a motion to adjourn?
No.
Oh, I'm sorry. I felt like you were already up here.
No, I know. I just want to bring to the Commission's attention that a Scrivener's error was made by a public citizen about the June meeting minutes. There was an item regarding the advocate's evaluation in which the minutes read that the evaluation approval was moved by Commissioner Noreen and seconded by Commissioner Noreen, and that obviously was an error. The minutes have been changed to reflect that the evaluation approval was moved by Commissioner Noreen and seconded by Commissioner Bernier.
Okay. And you went back to confirm that?
I had them, yeah, it was strictly
Scrivener's error.
an error, yes.
Anything else? Do I have a motion to adjourn?
So moved.
Second.
This meeting is adjourned. Thank you, everyone, for being here.
Mr. Chairman, the Honorable Attorney's comments should have been made under comments, not under old business. Because I bet if I'd have done that, I'd have been told, no, you should have said that in comments.